my name is David Donnelly, and I represent with our firm Donnelly Law, Action Milton. We are very active in the province of Ontario, representing citizens groups fighting inappropriate developments such as highways, quarries, and urban sprawl. Early on in the process, we did provide an opinion to Action Milton with respect to the need or the desirability of an environmental assessment. And that opinion, I don't mind sharing, was very much that an environmental assessment is a superior form of review to the LPAT process, which relies on a thing called the Joint Agency Review Team, or JART process. And for reasons that I'm going to get into when we discuss the pros and the cons, in fact, the EA process is superior to a municipally led JART process. Having said that, the EA carries with it some risks and costs, and ultimately it is my opinion that I've expressed to Action Milton. An EA is just another form of process, and by no means is a guarantee that the community will receive what it really wants, which is of course a stop to the quarry, as has been promised by the Premier. And in fact, the EA process may make it more easy for the JDCL to run its application through to an ARA license approval. So having said that, I prepared a short slide presentation, which I'm hoping we can use. Terrific, thank you. So if we can go to slide number 2. The JDCL quarry at approximately 1 million tons per year is considered to be a very large quarry by Ontario standards. Anything around 1 million tons per year is considered to be a substantial undertaking. And this quarry, of course, has a very unique feature, which is that it is going to include underwater blasting and mining. And that in terms of its physical location, the quarry is located very near to residences, and including the very sensitive receptor being the 401. As most of you probably are aware, the 401 is a very busy thoroughfare. There are trucks, school buses, any number of residents that use that highway every day. And the question that we would have is, does the blasting put those travelers at risk? That's something to think about when we come to the EA process. If we could go to the next slide. Happily, on January 19, 2020, there was posted on the Environmental Registry a project-specific proposal to designate and exempt the proposed Reid Road Reservoir Quarry Milton under the Environmental Assessment Act. It is very rare that private undertakings, that would be projects that are done by private corporations, are designated under the EA Act. The EA Act is principally an infrastructure assessment tool that is used in Ontario for things like nuclear power plants, highways, garbage dumps, and the like. Now, there is a precedent for establishing an environmental assessment for quarries, which was the Melanchthon Mega Quarry, which is up north of Orangeville in Ontario, and I'll deal with that in a moment. But basically, this is something that is quite rare, which is the designation of a private sector project for an EA. Now, in terms of the next steps in the process, the next critical deadline is March 15th, when the province of Ontario has asked for comments from the public and from public agencies, like, for example, Conservation Halton, Town of Milton, and the region of Halton. The purpose of those comments is to give the government some indication or direction with respect to what people's expectations are with respect to the scope or the terms of reference of the project. That is, will we be looking at everything, including natural heritage, species at risk, traffic safety, air quality, hydrogeology, noise, dust, air quality, or will the environmental assessment terms of reference be limited in its scope or narrowed to include only, for example, the matter of underwater mining and blasting? Now, we have some indication about where the government thinks it's headed in terms of the posting on the Environmental Registry. We could go to the next slide. This is drawn from the ERO posting from the ministry. And in the announcement on the website, it said the notable provisions of the proposed regulation would include, and again, this is sort of the government, someone in government posting something that they think indicates where the government's mind is at. But there's by no means a guarantee that this is what an environmental assessment will look like. It says that specific requirements for the content of the environmental assessment would include a description of the purpose of the undertaking, a description of a statement of the rationale for the undertaking, and any alternative designs specific to the implementation of the undertaking, such as assessing an alternative to underwater blasting. Now, that's an important point, which is to say that in the consideration of the alternatives, they're really looking at, is there another feasible way to extract this aggregate not being underwater, which would obviously be in a pumped condition, which would raise a whole host of other environmental issues and complications for the project. So that is certainly good news that the government understands that the EA is targeted essentially towards this very novel approach to underwater mining and blasting. However, there's a bit more good news in terms of what is promised, but not yet delivered in a regulation setting the terms of reference. Now, the project proponents, being JDCL, are required to provide a description of the environment that will be affected or that might reasonably be expected to be affected directly or indirectly, the effects that will be caused or might reasonably be expected to be caused to the environment. That would include the natural heritage, species at risk, but it would also include residents or receptors compatibility issue, such as noise, dust, vibration, light, and all the compatibility issues normally associated with the quarry. The description of the undertaking must include the actions necessary that may reasonably expected to be necessary to prevent, change, or mitigate and remedy the effects upon or the effects that might reasonably expected upon the environment. Again, that's reasonably broad. And then finally, additional specific studies pertaining to groundwater, including a door-to-door well survey program, water quality monitoring program, an assessment of the effects to groundwater from blasting below the water table, and other studies such as fugitive dust, that's air quality, and haul route conditions. That would be the traffic study, but we would also hope that would include the traffic safety issue on the 401. So some of the indicators with respect to the scope of the terms of reference are positive. However, there is no guarantee coming yet from the government that this will be a broad environmental assessment, which is what I think we all want. If we can turn to the next slide, please. In terms of the EA process, the terms of reference will be established to set the scope of the environmental assessment. And again, we have no indication of what that will be, although they have mentioned some specifics like the haul route, fugitive dust, which is an air quality issue, including PM 2.5, which is the fine matter particulate that has been identified as a carcinogen and is now regulated in places like Oakville and is under consideration for regulation in Burlington. The study or the EA process will take approximately 1 year. At the end of that, that EA study is vetted by the ministry staff and is either referred to mediation or is sent to the minister for a decision. We have the next slide, please. Now, the minister's decision can be built around a number of considerations. The minister has 3 choices: approve the undertaking with conditions, or refuse to approve the undertaking. That's actually canceling the quarry or canceling the part of the quarry operation, underwater mining and blasting, if that's what's identified in the scope or the terms of reference for the quarry. So this is a key determination. The question is, will the EA stop the quarry, or will the EA only stop the quarry, part of the quarry that's identified in the terms of reference, which would be the underwater mining and blasting component? I note here that there is something of a precedent in terms of the hidden quarry, which features a very similar type of technology or mining technique, which was approved by LPAT. So if you want to read the tea leaves, it looks like the MNRF and presumably the Minister of the Environment, Conservation and Parks, or MOE as we used to call it, has taken a careful look at this underwater mining and blasting and has already given it its blessing. So while there's a hopeful note, which is the scope of this review may be quite broad, there also is some precedent to suggest that the provincial government has already looked at this issue and at the very least gave the hidden quarry a free pass or a pass with respect to using this untested, somewhat novel technology. Now, once the minister receives the recommendation with the application, there's a and if it goes to mediation, there may be a mediator's report. However, the ministry's recommendation is just one matter that the minister takes into consideration when making a decision. The minister has discretion to make up his or her mind. In accordance with the subsection 9.2 of the Environmental Assessment Act, the minister must consider the following matters when deciding an application: the purpose of the Environmental Assessment Act, the approved terms of reference, the ministry review of the environmental assessment, that's of the studies that were undertaken, the comments submitted during 2 inspection periods, those are public comments, including public agencies like Conservation, Halton, the region, the town, the media's report, if any, and then finally, such other matters as the minister considers relevant to the application. And this leads us then to a consideration of what are the pros and cons of environmental assessment, because it's those other matters that are likely to be a key feature of this environmental assessment. In other words, do the socioeconomic, the social impacts, environmental impacts, of course, but other considerations, can they override the strict technical exercise or review of the process of, for example, underwater mining and blasting? We go to the next slide, please. Now, the history of EA in Canada is a very interesting one. As I suggested earlier, in Ontario, EA has been restricted primarily to nuclear power plants, garbage dumps, and other government infrastructure projects. More broadly, at the federal level, such projects as the Oldman River Dam, which set a Supreme Court of Canada precedent. If you've ever been on the Confederation Bridge or the fixed link in PEI, it was the subject of a great deal of litigation and a federal environmental assessment. Or low-level military flight training in Labrador at CFB Goose Bay is a very famous example of Aboriginal people and environmental defense here in Ontario engaging in a federal environmental assessment. So there is a long history of environmental assessment in Canada. However, it is a long and somewhat sad history because the vast majority of projects that have ever been subjected to EA have either been approved or approved with conditions. In other words, if you were to handicap the EA process, you would say that most often or most likely, proponents who follow a rigorous technical evaluation process will most often get an approval with conditions. In other words, if you're thinking that the EA process is somehow going to stop the quarry, that's highly unlikely based on precedent. Now, in terms of the pros, EA is unique or distinct from the Local Planning Appeal Tribunal or OMB process. However, the EA process has less of a and positively, the EA process has less of a track record. There have been dozens and dozens and dozens of quarries approved through the OMB or the LPAT process. There has never been an EA process run all the way through on a quarry. In other words, we're in somewhat of uncharted territory here, which is better than the OMB territory where the vast majority of projects get approved. Now, in terms of the EA process, what's a positive? The primary goal of EA is to integrate environmental, cultural, social, and economic effects of the project. So that the scale, the latitude of the assessment is quite broad. EA has been used successfully in scaring off the Melancthon megaquarry investors. The EA was credited with creating such a monumental hurdle in terms of the time and the cost that the US Best Investment Group, the Boston Group, simply gave up and withdrew their proposal. That was the Melancthon quarry near Orangeville, Ontario. The EA process can typically take up to 2 to 3 years to perform the entire process from the start of the terms of reference through the study, possible mediation, the review by the ministry, and then ultimately the minister's decision. The EA is generally perceived as being a much more exhaustive technical review than through the LPAT process. And that primarily with ARA or Aggregate Resource Act applications, that process is typically considered to be the captor of the Ministry of Natural Resources, which has a long history of approving quarries, versus an EA process, which is typically governed or the responsibility of the Ministry of the Environment, which is perceived, rightly or wrongly, as being much more cautious or progressive when it comes to environmental regulations or standards. Now, one of the advantages of this EA is that it may actually delay a minister's decision on this approval until after the provincial election on June 2nd, 2020, although we do have an indication that the timeline for this is to be 1 year, which would put the decision well before the next provincial election. And then finally, the request for a hearing, finally, that when the EA is sent to the minister, there is an opportunity for public agencies or the public to request a form of a bump up, which is to request a hearing on the EA matter before the Environmental Appeal Tribunal or the Environmental Review Tribunal in Ontario, which would further delay proceedings. And as mentioned previously, it seems like it's the commitment of this government that they will stay the LPAT ARA license decision until after the EA, so that we may be several years away from the LPAT hearing, if there's to be one at all. We can go to the next slides. I'd like to discuss briefly the cons of the EA process. The primary negative is that the EA is simply just one more process in a long chain of process. The EA does not replace the LPAT process. It is likely that the LPAT is still going to happen. While the EA may be a more in-depth review, this tends to be more costly for the public agencies. Or, in fact, this EA may simply be a rehash or repeat of the JART process, which is already underway and, in fact, is getting close to a completion. Now, the JDCL EA, as it appears, is fundamentally different from the Melanchthon Megaquarry, which dealt with a whole broad range of issues. The JDCL, at least from first blush on the registry, appears to be a much more limited in scope environmental assessment. That is to say, there's a one-year completion time frame that's been set out. It seems focused on underwater mining and blasting. And of course, there's the hidden quarry precedent. The decision of the LPAT came out after, of course, Action Milton's request for the EA. Second, another problem with the EA is it's generally perceived as being a more definitive review. That is to say, that the minister rarely goes against the recommendation of staff, which is the review or the EA itself. In other words, if you're hoping that the minister is going to swoop in at the end, disagree, or controvert the recommendation of staff, while that's possible, that has rarely happened in EA history. Typically, EA is a proponent-driven process. They're much better at getting to yes than they are at stopping things. And that through an EA process, municipalities are generally marginalized in the process. While the municipalities have great control over the JART, how much money is spent, who are the experts that are hired, how long does it take to do the review. In the EA process, all of that is transferred over to the ministry and minister staff, and the public agencies like Halton and Milton and even the public themselves are sort of an active bystander. There are opportunities to participate in the process, but we don't control the process. Most importantly, there's a problem with the EA process insofar as it takes the decision-making out of the hands of your municipal council. So presently, Halton Region controls the JART process. It controls the purse strings, it controls the timing, it controls who is let into the process. And most importantly, both Halton Region and the town of Milton have levers at their disposal, such as a minister's zoning order request or an interim control bylaw that would freeze the development for 2 years and allow Milton to impose new zoning bylaws to protect the public. Those are essentially taken out of the hands of the municipality through the EA process. Now, there's something else that's a con here, which is the EA process now, I think, has distracted people from something that is owed to residents by your municipal councillors, both the local and the regional councillors, and that is this. Halton Region is facing 2 significant mega quarry applications in terms of the JDCL Reid Road application and the Nelson Quarry application up on Mount Nemo. Halton Region should be taking a comprehensive, coherent approach to these quarries in urban areas. These should not be assessed on an individual EA basis or through a JART process. Your elected representatives should be taking a coherent position about whether they should be exposing residents to the health hazards of air quality problems, dust, quarry truck traffic, blasting impacts, and probably most important, threats to drinking water and the hydrogeology. Now, if we could have the next slide, please. Really, one of the primary problems that I have with the EA process is it's just more process. That it's hardly a definitive view of what the JDCL application will really mean to residents. And that in fact, if the scope of the study is very narrow, this is going to end up in LPAT altogether. Now, there is one person, one elected official in Halton Region that figured this all out. There's one politician that took a look at what is really needed here and what the public really deserves, and he had no hesitation whatsoever in deciding what was the best process for dealing with the JDCL application. And that person, that politician's name is Doug Ford. Now, he made a very definitive pronouncement with respect to the advantages of process versus a definitive promise to deal effectively with the application. I'm going to quote now from July 29, 2020. This is Doug Ford. I am not in favor of that, the Reid Road Quarry. I believe in governing for the people. And when the people don't want something, you don't do it. It's very simple. I know the mayor, he doesn't want it. No one wants it. I don't want it. We're going to make sure it doesn't happen one way or the other. Now that means a minister's zoning order. That means an ICBL leading to a study and more regulation. This does not mean an environmental assessment. If we go over the slide, please. I've got probably 2 more minutes. Now, what if the EA approves the JDCL with conditions? What happens then? Well, then the final word on the technical issues like air quality, truck traffic, hydrogeology will be left to the LPAT process. In other words, we won't be much further ahead. JART is central to the Milton Halton position at LPAT, but it is not a technical review. It has been advanced as a solutions-based process established to help JDCL work through its process. Town and Milton staff are currently relying 100% on the EA and JART. If the EA recommends approval, it's predictable, so will staff. Council rarely votes against staff recommendations, and that's a problem. Next slide, please. The jurisdiction concerns that I have with the EA are that Milton and Halton are currently spending big dollars on the JART process and now on an EA, which will be partly to assist JDCL in overcoming the issues with their application. The question I have is your time and money not better spent advocating for a definitive solution, a minister's zoning order, or by adopting an ICBL, which will allow you to put public welfare protections in place, for example, a 500-meter setback on residences in the 401 with respect to the blasting. That's a solution. An EA is not a solution, it's more process. We can have the next slide, please. Now, in my opinion, your town council is sleepwalking towards an environmental assessment approval. Town council does not appear to have a strategy for defeating the JDCL application via an environmental assessment. Planning staff and the town's legal counsel are against an interim control order or a minister's zoning order, which would create a local definitive solution to the problem. Council has even refused to direct staff to study an ICBL, or more importantly, refused to hire experienced outside experts, as Oakville and Burlington have done in the past, to deal with their air quality and quarry issues. Now, JART likely knows now whether the JDCL can pass an environmental assessment, and I think we should be told that now, so that we don't spend a lot of time and money chasing an EA that isn't going to give us the result that we want. Now, I'm very pleased to say that Melissa is here with us tonight with her community group and Mike Balkwell. They have shown what residents can do with respect to who's the boss. In Stratford, it's the residents who are the stars of the show, and the politicians are the spear carriers. In other words, when that community objected to the MZO that was imposed on their community, there was an uprising, and council refused to play Gigny's tune and essentially withdrew their support for the process, didn't respond to Gigny's request, and so Gigny withdrew their proposal. That's the way it should work in Milton, not the other way around. Now, in terms of next steps, in my last slide, Action Milton should take steps to comment on the EA terms of reference. They should be as broad as possible. Halton Region and the town of Milton should stop the JART process until Action Milton experts have been consulted regarding the EA and the role and function of JART. Milton Council must pass an ICBL or request a minister's zoning order or both. And my question is, what does council have to lose? It costs nothing. Finally, council must advise a strategy for an LPAT appeal that includes Action Milton and is proactive, that it anticipates a negative environmental assessment outcome. If the EA rejects the quarry, that's great, but we should be preparing now for an LPAT hearing plus the cost of an EA. In conclusion, while the EA is certainly helpful in terms of introducing another layer of process or study. There is nothing in the EA process that leads me to believe, and I've had 30 years experience with EA, there is nothing in the EA process that comes even close to the definitive solution that was proposed by that crazy radical environmentalist, Doug Ford. We want what Doug wants, not an EA. Thank you. Those are my submissions.